And it's probably, if we were to be very honest, Kim, it's probably that last one that's most important. The fact that our two daughters are good friends is what probably keeps us more honest than anything else, right? So thank you very much for the warm introduction, and it's tremendous to have the opportunity to be here with you. I always enjoy any opportunity I have to be in Saskatchewan and to be in Saskatoon in particular, because audiences here are always so engaged and so deeply committed to issues of rights and justice. So I really come away from time in Saskatchewan myself feeling bolstered and energized and confident that in communities, at the grassroots, there are so many women and men and young people who care, who are determined, who are not going to stay silent in the face of the deep injustices that we confront. And that, more than anything else, is what gives me hope. And given the topic I'm going to talk to you about today, we sure need hope. And I'm thrilled that this many people actually wanted to show up for a talk about torture. Obviously not a light and breezy topic, but certainly a very pressing human rights concern, has been for years and decades, in fact. And once again, with the debate that we have underway around Canada's proposed new anti-terrorism laws, is very timely and very current. And I'll come back to that theme several times during my remarks. The tension, the relationship, the confrontation, unfortunately, often between national security and the protection against torture, amongst other things. So an important time for us to be thinking about that and to be thinking about the safeguards we need in our national security laws to guard against complicity in torture, for instance. So in talking about torture, there's obviously many angles you can take, because there's so much that lies behind it, that explains it, that causes it, that fuels it. But here I am in a law school, and so it certainly makes sense to start with the law, doesn't it? And the law on torture is short, sweet, and simple. It's one sentence. No one shall be subjected to torture. You don't need a statute. You don't need pages and pages of legal provisions. It's a very clear statement of law. And there's a lot packed into that. It means no one. It really does mean no one. We're going to come back to that several times. It means anywhere. It means anytime. No excuses. In fact, there are very few human rights that are stated in such clear and unequivocal terms as the global ban on torture. Within international human rights law, there's only one other treaty, for instance, that uses the same language, and that's the UN Convention dealing with enforced disappearances, another obviously egregious human rights concern. And both of those treaties go on to say the following. They don't stop at saying no one shall be subjected to torture. They go on to say no exceptional circumstances whatsoever, I love that word, whatsoever may be invoked as a justification for torture. Well, I may love the word, and whatsoever may be an impressive word, but the contrary, and I would suggest very painful truth, is that the absolute certainty of the ban on torture is matched by an equivalent glaring gap between promise and reality. So just as certain as the ban on torture is the width of the gap between promise and reality. Now I'm going to take us through a journey that's going to look at a variety of dimensions of this from a law and policy perspective, all with a Canadian angle. But before I do so, before I get lost in ministerial directions and sections of UN treaties and references to the criminal code, let's not lose sight of the fact that at the end of the day, at the beginning of the story also, this is about people. Torture is about human beings. It's about human pain. It's about human survival and resilience. And I want to start there. And of course, there are scores and scores of accounts I could share with you. but I'm going to share just one because it's still very fresh in my mind. And it was a case that I was directly involved with personally. And it takes me back to September of last year when I was part of an Amnesty International delegation that went into a maximum security prison in the Mexican state of Nayarit. I've done a lot of prison visits over the years. I've done a lot of maximum security prison visits over the years in many different countries. I've been to Guantanamo Bay 3 times. And I can tell you, I've never been through as much security as it took to get into this prison. The amount of X-ray scans and creative use of ultraviolet light and pat-downs and interviews and another interview and whatnot that I went through for well over an hour. You would imagine that I must have been there to interview some notorious kingpin in one of the Mexican drug cartels. But I was there to interview an Amnesty International prisoner of conscience and survivor of torture, a man named Angel Colon. He wasn't Mexican, he was actually Honduran. And in Honduras, he was a member of Honduras' Garifuna community, the Afro-Caribbean community in Honduras, whose members right along the Caribbean coast of Central America experienced deep, deep racism. He'd been a human rights activist, an environmental activist. He'd been studying for the priesthood. And how many more karma points can someone build up? But he also was faced with personal tragedy. His young 7-year-old son was diagnosed with terminal cancer. And Angel Colon, the activist, aspiring priest, had no money. And all that mattered to him was to be able to have enough money so he could afford the best possible cancer treatment to try to save his son's life. And thus began the migrant's journey. Well, think about it. If you can picture the geography, it's a bit of a journey. He makes his way all the way up through Mexico to Tijuana and is in a safe house waiting to cross over to find who knows what employment in the United States, and there's a raid. And he's swept up in the raid, and racism kicks in. The Mexican police are unable, refuse to believe that a black man could be anything other than a criminal. All his protestations about who he really is swept aside. He's taken into custody, and the torture begins because they're determined to get the truth out of him. And it went on and on and on. First, at the hands of the police, he was beaten repeatedly, mainly in the ribs. Ribs were broken. He was forced to walk around on his knees for hours at a time in the police holding cell. He was kicked, he was punched, he was hit with wooden batons all over, especially in the stomach and the back of his neck. And then it got worse, because then he was transferred to the military. The military blindfolded him, and they held him in a room where all he could hear were the screams of people being tortured and beaten in the adjoining rooms, and he got constant taunts and threats that that's what awaited him as well. Repeatedly, a plastic bag was put over his head and held there to the point of asphyxiation, so constantly taking him to the point of near death and back. It's like the dry land version of waterboarding. He was stripped and forced to walk around again on his knees, licking clean the boots and shoes of guards and other prisoners, made to hold degrading and painful stress positions for hours on time, and all throughout that, an endless barrage of racial insults thrown at him. That went on for, in his estimation, 16 hours nonstop, unrelenting, and he broke. As he said it to us when we visited him in the prison, I would have signed anything, and that's what I told them. Bring it on. I'm a criminal. I'm a member of the gang. Let me sign. Of course, to bring it to an end. But it wasn't the end of the injustice. He then disappeared into the bowels of this maximum security prison, hundreds of kilometers away from the border area where he'd been apprehended, and no one heard of him for 5 years. He tried to protest to anyone and everyone. I shouldn't be here. It wasn't true. I signed to end the torture. Listen to my true story. No one listened. He was never brought to court to face trial. He was never actually even officially charged. He wasn't given access to family contact for years, no access to a lawyer. Finally, he gets word out through the family of another prisoner who were there to visit their relative. And word makes it to Amnesty, we get lawyers involved, and the whole truth comes out. Well, we campaigned. We campaigned endlessly for his freedom, and fortunately, 5 weeks after our prison visit, he was freed. No charges brought. The Mexicans admitted that they shouldn't have had him in prison in the first place, and he's now back in Honduras. But here's what we need to remember here. Angel's experience is but one of not a handful, not a few dozen, not even just hundreds, but of thousands of similar cases in Mexico alone. Mexico, where over the last decade, torture has increased by 600% over the last decade. And of course, Mexico is just one amongst very many other countries. So what this reflects is the following. Torture, my friends, continues to haunt every corner of our planet. And I'm going to give you some numbers in a minute. And it haunts every corner of this planet through the ways that torture is routinely, brazenly, cruelly, insidiously, and always with absolute and total impunity carried out every single day. And that's why Amnesty International has, once again, this is the fourth time in our history, launched a major global campaign to do something about it. It's got a real simple name, Stop Torture. And we've launched the campaign because we simply cannot fail to do everything we can to address that glaring gap between whatsoever and the story I just shared with you of Angel Colon. Here's one quick statistic that quite starkly tells us why this is so necessary. As we were getting ready to launch the campaign last year, we looked at our human rights research over the 5 years preceding that. And when we put it all together, we realized that we had documented in those 5 years torture in 141 countries. That's 3/4 of the world's states. In 2014, not in 1964 or 1977, in 2014. As I said, this is the fourth time in our 50-plus years that we've launched a major campaign against torture. We did so for the first time back in the 1970s. And then we did so because it was clear to us that torture was behind virtually every aspect of our human rights work. A prisoner of conscience case, an unfair trial, an enforced disappearance, you name it. And torture was there. It had happened, or it was about to happen, or it was a risk. It was always there, but no one was talking about it. The world was silent about torture. Too uncomfortable to discuss it, too much of a taboo to try to understand it, and too graphic for polite company to talk about. So we set out to change that, to make sure that the public, and of course governments, understood that we did have a reality of torture, that it was widespread, it was pervasive, and it was debilitating. We came back to it for a second campaign in the 1980s, and this time we knew we had to do so because the laws against torture had to be made much more clear, more forceful, and more universal. And we succeeded. Most significantly, coming out of that campaign, the UN agreed to and adopted the relevant treaty, the UN Convention Against Torture, just 30 years ago. Now ratified by 155 states. It's one of the most widely ratified human rights treaties. Now, some of you who are smart will think, but didn't he just tell us something about 141 countries that are carrying it out? So, boy, does that frame the challenge we have here. 155 states on board with the treaty, 141 countries still carrying it out. But it wasn't just about the treaty. Actually, coming out of that in the latter part of the 80s, it really sparked an impressive wave of national lawmaking right around the world. New laws, new constitutions, all banning torture. And it's in and around that time, of course, that our own charter was adopted. It doesn't talk about torture per se, but it clearly bans cruel or unusual treatment or punishment, which obviously is about torture. Our third campaign, very ironic timing, as you'll see in a minute, was 2000 and into the first part of 2001. And that campaign aimed to expose the circumstances and conditions that make torture possible. And we pointed to discrimination above all else. We highlighted the secrecy and the silence that surrounds torture and protects torturers. And we spoke of the complete impunity that shields those who commit these crimes from facing any kind of justice. Well, of course, the ironic piece is no sooner had we wrapped up that third campaign than September the 11th, 2001 hit. And we were faced with setbacks and challenges unimagined in the campaign against torture, because suddenly governments that had been never perfect, but nonetheless champions of all of the gains we had achieved in the important struggle to end torture, were, to say the least, no longer quite so reliable anymore. Instead, led obviously by the United States, but including many others, including Canada, as I'll come to later, those advocates now often committed it, or encouraged, or tolerated, or willingly benefited from torture. All, of course, allegedly in the name of keeping us safe and defeating the terrorists. So here we are in 2015, 14 years after 9/11, so more than a decade of responding to that rollback on torture, and it became clear that we absolutely needed to bring the might of a global campaign to this issue once again. And it's not just about national security and terrorism. Obviously, that features prominently in the work we're doing right now. But it doesn't stop there. It is much wider than that. Angel Colón's case speaks to that. You know, that's a case about racism and discrimination. No one ever accused him of being a good friend of Osama bin Laden. Or to think of another very current case of concern for us, Amnesty, and I'm sure many of you in this room have followed and have been very active on the case of Raif Badawi in Saudi Arabia, the blogger who has been sentenced to an unbelievable judicial punishment of torture. 1,000 lashes. Well, similarly, no one's talking about him as a terrorist. He's insulted Islam, he's been outspokenly critical of the government, all sorts of things. So we can't fool ourselves into thinking that, you know, the challenges we face about torture in the world today are simply an outcome of September the 11th. So that first campaign was to build awareness about torture. The second was to strengthen the laws against torture. The third was to understand and tackle what makes torture happen. This time out, we're focusing on the concrete steps that can be taken to stop torture. It's all about safeguards and prevention. Because, of course, at the end of the day, that's what we want. Amnesty International doesn't want to spend the next 50-plus years responding, reacting to torture. We want to move to a world where we've prevented it, where it's not happening in the first place. Let's remind ourselves about why that language I shared with you at the beginning, whatsoever, no exceptional circumstances, is so important. Torture is never excused because it so fundamentally destroys the very essence of dignity and integrity on which the entire concept of having human rights in the first place rests. And when we allow torture, what we do is we widen divisions. We leave behind a growing list of victims and survivors. It maims, it dehumanizes, it traumatizes, it very often kills. Individuals are brutalized, yes, but far beyond that. Their families are terrified. Entire communities are terrorized into silence. And really, in the end, all torture does is lay the ground for more human rights violations, more violence, and deeper insecurity. So that's why every single time the ban on torture has been included in international human rights instruments, governments, and remember, governments are the ones who had the pen. It wasn't Amnesty International who got to sit down and pen that phrase in the Convention Against Torture. governments knew that there cannot be, must not be, any exceptions, because torture, for any reason, is the very antithesis of human rights. But it doesn't stop there. There's no exceptions as well because torture doesn't work. Not that we want this debate to come down to being a utilitarian debate about if someone was able to prove a productive way to torture people, it's fine. But it's important to remember this. People will say anything, they will confess to anything, they will finger anyone to bring the agony of torture to an end. That's what Angel Colon told us in that prison cell in Nayarit, and I have heard that repeatedly from the many hundreds of torture survivors I've interviewed in Canada and in prisons and refugee camps around the world. But here's another reason, and this one is absolutely crucial. No exceptions as well, because torture does not stop. No matter how or who may try to convince you otherwise, never believe that there's any such thing as just a little bit of torture, right? And you know the argument. It used to be, of course, before September the 11th, it was the famous ticking time bomb scenario. Now it's the terrorist mastermind scenario. And we have that fictitious terrorist mastermind who, for whatever reason, we have 100% certainty that we know he's plotted an attack. Well, surely it's okay to torture him to get the information about the attack and save hundreds, maybe even thousands of lives. Well, then surely if it's okay to torture him, it must be okay to torture his accomplice. Well, then it must also be okay if the mastermind and the accomplice are in hiding, surely it's okay to torture the accomplice's wife, because she must know where they're hiding. And maybe it's okay to torture her son to put pressure on her, and the son's cousin, and someone who went to school with the cousin, and someone who attended the same mosque, speaks the same religion, language, worships the same God, and on it goes. And I'm not just being wildly conspiratorial here. That is the reality of torture in every country that Amnesty International has researched in any corner of the world over the past 50 years. Once torture is allowed against anyone, it can and will be used against everyone. Torture's reach doesn't stay confined. It only expands and goes further and further. So during the campaign, Amnesty International here in Canada will absolutely be putting pressure on the Mexican government, will be putting pressure on the Saudi government, will be putting pressure on governments around the world to end torture and to adopt the reforms to prevent it. But we're also going to be turning our attention to our own government. Now that's not because, I don't want you all rushing out if you're thinking, oh, Amnesty International says torture rampant in Canada, major campaigning priority. Well, we're not focusing on Canada because torture is rampant in the country. Angel Colon's experience isn't playing out in Canadian police stations and prison cells every single day in the thousands as it is in Mexico. Although I'm not going to let us off the hook. I am going to, in a moment, highlight, as an example, the shocking levels of solitary confinement in Canadian prisons and what that says to us about torture. But even beyond that, there is much that Canada can and must do to significantly strengthen its contribution to ending torture. And I'm going to take you through 4 areas of concern. The first is detention practices. The second is complicity in torture. The third is justice for torture. And the last is oversight to prevent torture. So let me begin with the first, detention practices. And as I just noted, while torture in Canadian jails is by no means widespread and systematic, there is one area where we absolutely have to become much more commonplace about uttering that word, torture, the country, Canada, in the same breath. And that's when it comes to the high use in Canada of solitary confinement. which of course we don't call it in Canada. We call it something different. We call it administrative segregation. I guess we cross our fingers and hope that if we call it something else, it becomes something else. That's certainly not the case. Let's pause and think about this in the international context for a minute. Solitary confinement is actually of increasing and very serious concern within the international human rights world. And particularly of note here is that in 2011, the UN's preeminent expert on torture, long title, known as the UN Special Rapporteur on Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, I'm just going to call him the Special Rapporteur, presented a global report on this topic to the General Assembly, solitary confinement and torture. And it was hugely consequential. It was the first time at that kind of a level that we had that sort of an expert putting this issue in front of world governments and linking the two, solitary confinement and torture. And he defined solitary confinement as the following: the physical and social isolation of individuals who are confined to their cells for 22 to 24 hours a day. Correct me if I'm wrong, Kim, but that's administrative segregation in Canada. So yes, it is solitary confinement. Now I want to pause here for a moment. I'm actually going to do this a couple of other times as well, and I guess I'll call it sort of a terminology check. Because there's a few times where words are going to come up in my comments that I often feel kind of get soft-pedaled. You know, we don't, even those of us who follow the issues and who are concerned, don't readily grasp or appreciate the gravity of what we're talking about. And I often think that's the case with solitary confinement. You know, oh, unfortunate, probably not much fun. Boy, you must get really lonely. You know, but that's where a lot of people's thinking goes. And we absolutely have to confront that. And I was really struck by this short passage from the Special Rapporteur's report in which he tries to capture what's at stake here. And nothing could better state, I think, why it is so obvious that we need to be talking about this under the framework and rubric of torture. So he says the following: being confined in isolation produces severe and sometimes very often irreversible physical and psychological effects. Anxiety, depression, anger, intolerance of social interaction, cognitive and perceptual distortions, paranoia, psychosis, self-mutilation, and suicide. He then goes on to conclude that in many situations, any use of solitary confinement in and of itself is torture. People with mental illness, young people. But then goes further and says that the impacts are so severe and, as he's noted, so often irreversible that in no circumstances should solitary confinement ever extend beyond 15 days, and that when it does, it is ipso facto torture or ill treatment. Some pretty strong stuff at UN level. What about Canada? Well, many of you likely know that the practice of solitary confinement in Canada, and I'm going to call it that, has become widespread, far beyond the UN's suggested limits. Here's something from the Office of the Correctional Investigator, the independent body charged with oversight of federal prisons. He notes, while the law requires that segregation be used as a last resort, and that's what international law says as well, and that's certainly what the Special Rapporteur is highlighting, last resort and for the shortest period possible, the practice is the contrary. It has become a standard tool of population management to maintain the safety and security of federal institutions. On any given day, about 850 of the 14,700 offenders in federal institutions are in segregation units, and the proportion in provincial institutions may be even higher. And those are, I think that's from a 2011 report. Who knows what we would find today? Well, that's more than 5% of federal prisoners in solitary confinement at any one time. I don't know about your sense of what absolute last resort means, but 5% doesn't cut it for me. But of even graver concern is the amount of time. Remember that 15-day cap I just talked about? Well, the average, and again, this is a 2011 figure. Kim could probably give us more recent figures. The average length of time in segregation at that point was 40 days. That's the average. That means there's a whole lot above that, and some under. But it suggests there's not a lot underneath 15. And that over 10% of segregated inmates at any one time have been held in solitary confinement for more than 4 months. Well, it's not just about numbers, and it's not just about UN reports. There's, of course, a tragic human cost to all of this. Everyone will know the case of Ashley Smith, whose, and depending on your perspective, you would use different words here. You would say her death in custody, you would say her suicide in custody, you might say her murder in custody, was the subject of a coroner's inquest. We also have recently seen the powerful reporting in the Globe and Mail of the tragic case of Edward Snowshoes. Those are the kinds of cases that really tell us what's at stake here. So given all of this, the UN Committee Against Torture, which is the preeminent body charged with pushing countries to live up to their obligations under that whatsoever document, the Convention Against Torture. Well, in their 2012 review of Canada's record, they do that every 5, 6, 7 years, they do a review. They were aghast and alarmed about solitary confinement, and they called on the government to overhaul policy and practice. That was declined. More recently, of course, after a full year of deliberation, the government similarly more or less rejected the Ashley Smith coroner's inquest recommendation that solitary confinement be reined in. So I guess not surprisingly, groups working on this issue at the front lines are now turning to the courts. There's lawsuits that have been launched in both BC and Ontario. And bring it on, I say, because I think it's going to take judges now to tackle what I think we have to start to call what it is, and that is Canada's torture disgrace. All right, that's Canadian prisons. I want to shift to the second theme, which was the issue of complicity. And here's my second sort of terminology check, the word complicity. Because I think, again, that's one of those words that people hear it and they think, oh, phew, okay, this isn't the awful stuff. This isn't the person who's doing things to fingernails or doing awful things with electric shocks. This is someone at a distance. We don't have to be terribly alarmed here. Think again, friends. Let's first think about the torturer, the individual inflicting that terrible pain. I can assure you, from all of the research we've done on torture all over the world, it's never about one person. It's never about two people. There is always a cast of people who make it possible, who order it, who model it, who encourage it, who look the other way, who refuse to investigate it, who reward the person who carried it out, who lie and cover up after it's happened. Well, the same thing happens with governments. Just like other people have the torturers back, other governments have the torturing governments back. They hand over the people to be tortured. They refuse to criticize them in UN settings. They stand back and willingly receive the information and intelligence coming out of torture chambers. The bottom line is, without complicity, I won't go so far as to say we wouldn't have torture, but I'm fairly confident in saying to you we'd probably have about 95% less torture. So this matters. It matters a great deal. And it's a very serious issue for us as Canadians because this is where we go wrong time after time after time. Canada has been complicit in torture. We continue to allow the possibility of complicity in torture. We have laws and policies that authorize, legalize the possibility of complicity in torture, and we've got to resolve this. For instance, it is unacceptable, it's disgraceful that more than 6 years now after a judicial inquiry headed by a former Supreme Court of Canada Justice, Frank Iacobucci, cataloged a long list of ways that both action and inaction on the part of Canadian officials contributed to the overseas torture of 3 Canadian citizens, Abdullah al-Malki, Ahmed Abu al-Mati, and Muyad Nuruddin in Syria, and in Mr. al-Mati's case, also in Egypt. The torture happened over a decade ago. The report from Justice Iacobucci's inquiry was 6 years ago. And these 3 men now are trapped in a nightmare of protracted and demeaning litigation, just trying to get the apology, that simple word, sorry, and an appropriate level of redress for Canada's complicity in that torture and other human rights violations. Well, it's not acceptable if we ever stand in the way of survivors of torture obtaining justice and redress. But it is beyond the pale when we refuse to remedy and apologize for torture that we ourselves made possible. Those concerns about Canadian complicity in torture also include the disturbing revelations of what have come to be known as the Ministerial Directions, which have been issued to a whole variety of agencies and departments now. We're having to pull this out through some Canadian press access to information requests, but we now have a pretty good picture that it includes CSIS, the RCMP, the Canadian Border Services Agency, the Communications Security Establishment, the Armed Forces. And what these ministerial directions speak to is, what do we do about concerns about torture in our intelligence relationships? You probably hope and assume that those ministerial directions firmly reject it. Well, they don't. In 2 different and very troubling ways, both with respect to incoming intelligence, so information that comes in, and we have good reason to believe that it was obtained through torture in another country. Do we reject it? Do we send it back? Do we urge that the country that gave it to us launch investigations and find the torturers and prosecute them? No. We have the green light to use it. In exceptional circumstances, but let's go back to that word whatsoever, there's no such thing. There's no such thing as exceptional circumstances for torture. Similarly, the ministerial directions green light sending intelligence out of the country, even when we think doing so may cause torture in another country. It is as if Justice Iacobucci's inquiry never happened, because that's what that was all about. All of the reckless, negligent, intentionally or negligently so, information sharing coming out of Canada, going to other agencies that set those guys up for torture. Guess we didn't learn anything from that. That's what Maher Arar's case was all about. Another judicial inquiry, another prominent and respected judge, Dennis O'Connor from the Ontario Court of Appeal. In fact, in his recommendations, he could not have been more clear on this second piece in particular, the outgoing intelligence. And it's real short. It's amazing how the real meaningful stuff when it comes to torture is just 1 sentence long. This is recommendation number 14 from his 2006 inquiry report. Information should never be provided to a foreign country where there is a credible risk that it will cause or contribute to the use of torture. It's pretty straightforward. It's actually nothing new. He's actually stating what the law is. But there it is in a very important judicial inquiry. Well, the ministerial directions, which should have been the moment to operationalize, to implement that recommendation at a minimum, go in exactly the opposite direction, and they allow what should instead be unconditionally forbidden. This is another area where the UN Committee Against Torture is very worried. They've called on Canada to revise the ministerial directions, and once again, Canada has politely declined. I would just leave with you, just to make this a little bit more contemporary, that these ministerial directions are now of even greater worry given what we face in terms of the stunning new approach to information sharing proposed in Bill C-51, the Anti-Terrorism Act, currently before Parliament. Information sharing beyond anything we've ever seen in Canada, based on the most expansive, almost limitless list of threats to the security of Canada you could possibly imagine. It's such a long list. Terrorism actually is only number 4 on the list. It's not even the top of the list. With virtually no safeguards, checks and balances in place to guard against everything we thought we'd learned from the Arar inquiry and the Yakabuchi inquiry? Let's make sure the information is relevant. Let's make sure the information is accurate and reliable. Well, we're going to be having this wildly wide information sharing happening across government departments and agencies against the backdrop of then this likelihood of how and when it can then be further shared internationally. It all fits together in a very worrying way. We then have what I often referred to as what feels to me to have become our institutionalized complicity in the serious human rights violations, including torture and ill treatment, endured by Omar Khadr. Human rights violations that, of course, began from the moment of his capture on the battlefield in Afghanistan in the summer of 2002, and the refusal at that point to recognize and treat him as a child soldier, and which included various episodes of torture and ill treatment, initially at the notorious U.S. Air Base Bagram in Afghanistan, and then continuing after he was transferred to Guantanamo Bay in October of 2002. Well, of course, there's a whole speech I could do on Omar Khadr, and I'm not going to. I want to focus on this particular issue of Canada's complicity in torture. Think of the following. The Supreme Court of Canada, and I hope this is kind of registering with you. I talked about Frank Yakabuchi. I talked about Dennis O'Connor. Now we've got Supreme Court of Canada rulings. This isn't the ravings of civil society groups. These are coming from the most authoritative sources within our legal system. And the Supreme Court of Canada ruled in January 2010 unanimously that Canada had been complicit in Omar Khadr's torture at Guantanamo Bay. Okay. I'm editorializing. They didn't use the word torture, but here's how the court put it. The interrogation of a youth detained without access to counsel to elicit statements about serious criminal charges while knowing that the youth had been subjected to sleep deprivation, I'm going to come back to that, and while knowing that the fruits of the interrogations would be shared with the prosecutors, offends the most basic Canadian standards about the treatment of detained youth suspects. That's code for the court saying that Omar Khadr was subject to torture when his U.S. captors used sleep deprivation against him, and that Canada became complicit in that torture when Canadian officials showed up not to protest, not to try to end it, but showed up willing and enthusiastic about benefiting from the fruits of that mistreatment. So now we need the third, what did I keep calling them? Terminology breaks or something there? Sleep deprivation. Because I think this is another one of those terms that often gets soft-pedaled. Oh, okay, that's not the really awful stuff. Boy, it's what, kind of like just really extreme insomnia? It is not. This is one of the most insidious and brutal forms of psychological torture. And don't take it from me. Listen to this passage from, of all people, I think this is the only time I ever quote him in anything I do, Menachem Begin, who was the Prime Minister of Israel between 1977 and 1983, and who in his youth had been tortured brutally by the KGB in the Soviet Union. And this comes from his memoir, where he notes that sleep deprivation, all of the torture he was experiencing, sleep deprivation is what finally pushed him to lose his will to resist. In the head of the interrogated prisoner, a haze begins to form. His spirit is wearied to death, his legs are unsteady, and he has one sole, all-consuming desire: to sleep. Anyone who has experienced this desire knows that not even hunger and thirst are comparable with it. I came across other prisoners who signed what they were ordered to sign, excuse me, only to get what the interrogator promised them. He did not promise them their liberty. He did not promise them food to sate themselves. He promised them, if they signed, uninterrupted sleep. And having signed, there was nothing in the world that could move them to risk again such nights and such days. That is what Omar Khadr endured. That is what Canadian officials knew he endured. And those officials, as I said, rather than complain about it, rebuke his jailers, even mildly, went along with it, ready and willing to make use of any information gleaned from a sleep-deprived youth. Well, the Supreme Court of Canada went on to say that Omar Khadr has a right to a remedy for all of that, which they found constituted a clear, unanimously found, a clear violation of his charter rights. Well, 5 years later, that's not happened. Any of you who follow Omar Khadr's case will simply know that, yes, he's no longer held at Guantanamo Bay, but he's still being held in prison here in Canada. And in fact, the Canadian government is now forcefully fighting. It's going back to the Supreme Court of Canada. His case is about to come before the Supreme Court of Canada for the 3rd time. I don't know if there's any other Canadian citizen, there may be one or two, who can say that the Supreme Court has ruled on their case 3 times. And this time, it's all about whether or not he should be recognized as a juvenile offender for the purposes of how his sentence should be handled in Canada. He was 15 years when he committed what he pled guilty to. 15 years old, it's real clear, but not to the government. They insist he needs to be treated as an adult. That means they get to hold him in a maximum security prison, and that means all of the kinds of programming that he would have access to as a youth, as a former child soldier, not available to him. And it also has dramatic implications for possibilities around parole release and likelihood of parole release, etc. So that's where that stands. Another unresolved concern about complicity and torture that lingers from the past is, do you remember that question of a few years ago about that whole thing about how we were dealing with prisoners on the battlefield in Afghanistan? Some of you may recall that it was quite the issue du jour for a couple of years. In fact, it led to prorogation of Parliament, nearly provoked a constitutional crisis at a certain point. The government was found in contempt of the House. At least one, if not more than one, ministers resigned. But let's put all of the politics aside, because what this issue was about, of course, was Canadian soldiers handing over prisoners to Afghan officials, despite the fact that there was clear evidence that many of them faced an almost certain risk of being tortured in Afghan jails. That is complicity in torture. Well, we, along with the British Columbia Civil Liberties Association, took the government to court on this because we had tried everything we could to encourage them to develop a different approach, a new policy. We weren't saying don't take prisoners. We were just saying handle those prisoners in ways that meet international law and don't risk drawing us into torture. And we had some early victories in that court case. There were a number of preliminary rulings that went our way, and judges were expressing alarm and concern about the evidentiary record. But before we could get to a full hearing, the case fell because the courts agreed with the government's position that the entire legal basis of our claim, which was the Charter of Rights, those of you who have perhaps studied or will be studying public international law will know that in a Canadian court you don't get to walk in waving that wonderful UN Convention Against Torture and say, Your Honor, I'm here to seek an order under Section 2 or Article 2.3 of the Convention Against Torture. You have to be waving around a Canadian law, the Charter very often, and then yes, you can use the international law to help encourage a particular interpretation. Well, the government argued and the courts agreed that the Charter doesn't leave the country, so that when our soldiers leave Canada, the Charter doesn't travel with them. And so when they're acting in Canada, they're not bound by the Charter. The Charter does not apply. And poof, the legal basis of our claim had disappeared. And so it stands. But it's an issue that will almost certainly arise again. Northern Iraq, he asks with a question mark, and which we absolutely are going to have to find a way to address. The answer to concerns that our troops might be drawn into complicity and torture can't come down to a maximum along the lines of, well, that may be so, but don't worry, the Charter doesn't apply. Obviously, we need a more principled solution. The last area of complicity I want to flag is deportation. And it's important to underscore here that international law is not only, we don't only have that whatsoever language about torture itself, it's also absolutely clear that nothing ever excuses, justifies, or allows a deportation or extradition or surrender of someone from one country to another if they're going to face a serious risk of torture in that country. Any of you who have studied or worked in refugee law will know that that's what we call protection against refoulement, to torture. Well, that's international law. Canadian law leaves open the possibility that a deportation can go ahead, even in the face of a clear risk of torture. And that's if the government asserts that there are serious security or criminality issues in the case. And that's been challenged and sadly upheld by the Supreme Court of Canada in its 2002 Scourge ruling, a case that will forever be a hostage to history. Argued before September the 11th, judgment rendered after September the 11th. I've always wondered if the court had ruled on September the 10th, would we have different and better law on deportation and torture in Canada? The court did rule that the normal rule is that no one should be sent back to face torture, but did say, without defining it, that there may be exceptional circumstances, there we have that again, which would justify a deportation to torture. Well, over the 13 years since, there have been many contentious legal battles around this thorny issue, and many deportations have gone ahead. And it's often very, very difficult to trace what has happened, but we do know of a number of cases in both Sri Lanka and India where torture did, in fact, take place upon return. So this is not just theoretical. It's an issue that will almost certainly at some point come back to the Supreme Court, at a minimum, to perhaps define the scope of exceptional circumstances. But one hopes to actually revisit this, and I'll remain hopeful, perhaps get rid of the very notion of exceptional circumstances in the first place. So there's a lot about complicity. And don't worry, I'm not going to take as much time on the other two themes that I wanted to share with you, but I think we really need to be aware of the range of concerns there about how it's played out for individuals, what exists in Canadian law, how this connects up with some of the proposals that are in Parliament right now. I now want to turn to justice. And here, too, international law is very, very strong. With respect to criminal responsibility, torture is recognized to be an international crime, subject to what's called universal jurisdiction. And what that means is that all states have a shared obligation to ensure that torturers are brought to justice, even if the torturer is not your national, even if the victim or survivor of torture is not your national, even if the torture didn't happen in your country or anywhere near your borders. Because this is a crime of the highest order in international law, every government is obliged at all times to act to ensure that any torturer is brought to justice. So that's what international law has to say. And here's an area where Canadian law is actually very good as well. We incorporated all of that in the criminal code when we ratified the Convention Against Torture way back in the late 80s. Right there in the criminal code, universal jurisdiction for the crime of torture. So international law good, national practice wanting, to say the least. In fact, over the close to 30 years now since those provisions were enacted in the criminal code, there has not been a single criminal code prosecution for torture abroad in Canada. There's been many cases, but they've all been dealt with under the immigration system, because our approach is just get rid of them. Just kick them out. Well, where does that take us? Maybe the torturer himself is now going to be tortured, and that's keeping us trapped in some sort of wonderful circle, isn't it? Or, probably more likely, absolutely nothing. Walk off the plane, scot-free, no one cares. Maybe there's been a change of government, and they're now have all sorts of allies and cronies in power. They get a hero's welcome. And where's the justice in any of those scenarios? We've either got injustice or no justice. Well, that needs to change. It's not just about criminal law, however. Torture survivors or their families, if they've succumbed to torture, have a right to redress for what they've endured. And there have been many attempts by individuals in Canada. Canadian citizens, Canadian permanent residents, Canadian refugees, to turn to the Canadian courts to pursue lawsuits against foreign governments for torture they experienced abroad. All of those cases have failed, and they failed because of one statute, Canada's State Immunity Act, which shields foreign governments from civil suits in Canadian courts for harm suffered abroad. But what is so outrageous about the State Immunity Act is it's actually not absolute. There is an exception. You can sue that foreign government for harm experienced abroad if it's related to a commercial matter. So you can sue the government of Iran for breach of contract that happened in Tehran. You cannot sue the government of Iran for torture that happened in Iran, even if you're the very same person. Maybe you're a business person who both had a deal go sour and were tortured in Iran. You get to pursue damages for the breach of contract, but don't bother talking about the torture. And unfortunately, last October, that was upheld by the Supreme Court of Canada in the case of Zahra Kazemi, which was a suit brought by the son of an Iranian-Canadian photojournalist, an amazing woman who had been imprisoned, raped, and tortured in Tehran's notorious Evin prison back in 2003. And the court concluded that the State Immunity Act protected Iran and that the lawsuit couldn't go ahead and that it trumped all other arguments. And we were an intervener. Everything was in front of the court. Everything about the UN Convention Against Torture. Everything about whatsoever. About the jus cogens status of torture in international law. But the court ruled 6-1, there was one dissent, that the State Immunity Act's wording was just so crystal clear that there was no way around it. I think they were uncomfortable about it, but they felt that there was no other outcome. So that means we're back to Parliament. And there is a lot of thought now around strategies for how to push for some reforms to the State Immunity Act to right the wrong of denying access to justice for survivors of torture. Let me now turn to the last area, which is oversight and review. We know that one of the reasons that torture continues at such alarming rates everywhere around the world is secrecy. Torture doesn't happen out in the open. It happens deep in the bowels of a prison. It happens while people are held incommunicado, in secret cells. And that's why it continues. No one's watching. No one gets access. No one's able to speak out about it while it's happening. And it's always been clear, therefore, that one of the key strategies of doing something about torture is to pierce that secrecy, end the silence. We need scrutiny. We need oversight. We need accountability. We need review. We need inspections. Well, here in Canada, obviously, we do have a lot in place. We have the Office of the Correctional Investigator. There's a lot of gaps in Canada. Provincial and territorial prisons in particular. There's certain detention centers that are subject to no oversight at all. Immigration detention at the hands of the Canadian Border Services Agency, for instance. But there is one particular area that I want to highlight here, and it's just so relevant because of where we are with the debate around Bill C-51, and that is the fact that we do not have meaningful review and oversight in Canada that looks at the complexity of issues that arise around national security operations. And you can see from some of the cases I reminded us of how important, how useful it would have been for Maher Arar if there was some oversight happening while his nightmare was unfolding. For Abdullah al-Malki, for Ahmed al-Mati, if someone was watching to see what's happening here, what's CSIS doing, what information is being shared, stop that. That cannot go ahead. Or at least some ability to have that looked at very quickly after the fact so that redress and accountability would be much faster and more meaningful. But we don't have any of that. We've got various agencies and bodies that do have some oversight individually over particular national security players, but we have nothing that brings it together in an integrated whole. And that was one of the key outcomes of the Meher-Arar inquiry. Justice Dennis O'Connor was given a mandate to look at national security oversight in Canada, and he was very clear in saying it's inadequate, and its greatest inadequacy is the fact that it's not integrated, and that we need an integrated model. All those agencies are working in an integrated way, more and more and more integrated. Imagine if it was already very integrated in 2006,